Good afternoon. In this webinar, I propose to consider circumstances in which a proprietary claim to assets may be established, whether that is a claim by a liquidator or another office holder, such as an administrator or a trustee in bankruptcy, against a third party, or alternatively a claim by a third party that assets ostensibly falling within the insolvent estate are subject to a proprietary claim. There are, of course, many circumstances in which proprietary claim to assets may be asserted. The range is broad and covers situations as diverse, to name but a few, as the scope of a security interest, retention of title, property held on trust to fulfill a common intention, for example, the purchase of a matrimonial home, payment of monies for an unfulfilled specified purpose, the so-called quis clos trust, recovery of monies paid under a mistake. What I'm primarily concerned with today are circumstances in which assets that are held on trust or subject to some form of fiduciary duty are misapplied and come into the hands of a third party, either with or without notice of the breach of trust. Now, that's not a situation, of course, that is limited to formal insolvency scenarios, and indeed, most usually form the key element of many commercial fraud claims. Many of those claims are, of course, brought by liquidators and other office holders in the course of recovery of assets for the benefit of their insolvent estates. The typical scenario, of course, is the improper transfer of assets away by the directors of the company in breach of fiduciary duty. In this talk, I propose to consider that as the standard template. Now, of course, various claims may be brought arising out of the improper payment or transfer of assets prior to the company's formal insolvency. Claims may, of course, be brought by a liquidator or an administrator personally against the direct recipients or potentially even more remote recipients, pursuant to claims under Section 238 of the Insolvency Act for transactions under value, 423 in relation to transactions defrauding creditors, and 239 in relation to preferences. Now, there are well-known limitations in relation to those claims. First, of course, in relation to preferences and transactions at undervalue, they may only be brought in relation to transactions or preferences that have been entered into within a relevant time prior to the company's insolvency, and at a time when the company was unable to pay its debts or became unable as a consequence of the offending transactional preference. Secondly, in bringing such a claim, the liquidator or the administrator is not asserting on behalf of the company a continued proprietary interest in the asset that's been transferred away. Section 241, subsection 2 of the Insolvency Act provides that the court has a range of powers available to it to restore the position of the company to what it would have been had the offending transaction not been entered into. Those remedies include the power to order the vesting of property or asset that's been paid away back to the company. That's Section 241(1)(a). Now, it's important to appreciate that these are discretionary remedies which the court may decline to order should it think fit. They're not assertions of a continued property interest by the company in the property. The asset that's been transferred away doesn't form part of the company's insolvent estate unless and until an order is made by the court on the office holder's application. This point was made clear in a bankruptcy case called Stoneman and Bratton, in which Lord Justice Lloyd said that before an order is made, in that case under Section 339, which is, of course, the bankruptcy equivalent of a transaction under value, it doesn't form part of the bankrupt estate. That's the whole point of proceeding to recover it under the section. It's only after an order is made that it forms part of the estate. So those statutory claims are not property claims as such. They're claims to request that the court exercise its discretionary powers pursuant to the provisions in the statute. Now, typical alternative claims that may be brought by the company as opposed to its liquidator or administrator, are one, that the company has a continued proprietary interest in the asset that's been paid away or its traceable proceeds. Two, that the recipient that's received the asset with sufficient unconscionable knowledge such that they are liable to account, the recipient is liable to account on the basis of being, of having knowing receipt of the monies or the asset paid away in breach of trust. Three, that a third party who is not necessarily the recipient of property that's paid away has dishonestly assisted the trustees or the directors in their breaches of duty to the company. Four, that the recipient has been unjustly enriched. Now, what I propose to do today is to look at two recent authorities that have reviewed and clarified some of the principles. My screen appears to have frozen. The first of these is a decision of the Court of Appeal in Byers and Saudi National Bank. That was a decision on appeal from a first instance decision of Mr. Justice Fancourt. That was handed down, judgment by the Court of Appeal was handed down in January of this year. The facts are relatively straightforward. The appellant was a Cayman Islands company, the Saudi Investment Company Limited, and its joint liquidator. It was the beneficiary of a trust in which the director of the company held shares in 5 Saudi Arabian banks. The trustee had transferred those shares to Samba Bank in Saudi Arabia in discharge of indebtedness that he personally owed to that bank. The defendant, the Saudi National Bank, subsequently acquired the assets of Samba. And the issue was whether or not the transfer of those shares gave rise to a knowing receipt claim against the Saudi National Bank as transferee of Samba's assets. Now, Mr. Justice Fancourt held that in order to succeed in a knowing receipt claim, the claimant had to have a continued proprietary interest. He dismissed the claim of the liquidator on the basis that Saudi Arabian law made no distinction between a legal and a beneficial interest. Accordingly, Saad had no continuing proprietary interest in the shares after the transfer because Samba, that's the bank's title, extinguished or overrode Saad's proprietary interest, even if Samba was taken to have knowledge of it. The Court of Appeal upheld Mr. Justice Fancourt's decision and affirmed his reasoning. Now, the elements of a claim for knowing receipt are threefold, and they were set out by Lord Justice Hoffman in El Aju and Dollar Land Holdings, in which he said to establish a claim for knowing receipt, a claimant has to show 3 things. First, that there's a disposal of assets in breach of fiduciary duty. Secondly, that the beneficial receipt by the defendant of assets which are traceable as representing the assets of the plaintiff. And thirdly, knowledge on the part of the defendant, the assets are received are traceable to the breach of fiduciary duty. Now, the third of those elements was considered by the Court of Appeal in BCCI and Akindele, where it was said that the recipient's state of knowledge had to be such to make it unconscionable for him to retain the benefit of the receipt, whilst the knowing recipient will often be found to have acted dishonestly. That's never been a prerequisite for liability. So liability for knowing receipt involves establishing each of the 3 elements being made. What's important and was significant in Byers was the interplay between the receipt of the claimant's assets and the defendant's knowledge. The Court of Appeal cited the judgment of Mr. Justice Millet in Agip Africa to the effect that a person who received trust property transferred to him in breach of trust can incur liability in two scenarios. Either he received it with notice that it was a breach of trust and that it was trust property and that the transfer was in breach of trust. Or if he received it without such notice, he subsequently discovered the facts that it had been a breach of trust. What matters are two factors. One is the recipient's state of knowledge that should have become such that it was unconscionable for him to retain the benefit of the monies paid away. And secondly, that he received the property with unconscionable knowledge or subsequently obtained such knowledge whilst in possession of the trust property. If the property was disposed of before the defendant obtained the requisite knowledge, then there'd be no liability for knowing receipt. All of this was rather succinctly expressed by the Court of Appeal in Byers in terms that unconscionability must coincide with the possession of the trust property for any liability to arise. Now, what that means is it's of no consequence whatsoever that the time that the action was brought, that the defendant does not still have the trust asset. Indeed, that's the very characteristic of a claim for knowing receipt. It's a personal claim. It's not a proprietary claim. If the defendant still retained the asset that's been misapplied by the directors, then the company has a straightforward proprietary claim to recoup its property. The defense that would be available to the recipient would be only that it was a bona fide purchaser for value in good faith without notice of the claim. Questions of knowledge don't enter into it in relation to a proprietary claim. The knowing receipt claim comes into its own in circumstances in which a proprietary claim is not available. Now, a good example of that would be where a defendant of the trust monies, let me rephrase that. A good example of all of this would be a situation where payment is made by the claimant to a defendant's account, which was in credit at the time when the payment was made. And at that point of time, there would have been a good proprietary claim to it, but the account is subsequently become overdrawn. Now, it's well established that it's not possible to identify property into an overdrawn bank account. The effect of that is that at that point of time, the proprietary claim disappears. What there is instead is a knowing receipt claim that the defendant has received property that's been paid away in breach of trust, that at the time that it was received, there was knowledge of the breach of trust. Assuming that to be the case, then the defendant and the claimant would have a claim for knowing receipt of monies paid away in breach of trust, but would not have a proprietary claim. Now, the principal issue before the Court of Appeal in Byers was whether the claimant could maintain a knowing receipt claim in circumstances where, although the asset was formerly trust property, i.e. it was held by the director of SARD on trust for it and had been paid away in breach of trust, its equitable proprietary status had disappeared or been extinguished. Now, SARD obviously, Byers and Saudi National Bank, it is an unusual case in that obviously it involves the question of foreign law and the applicability of foreign law, which didn't recognize the distinction between legal and equitable interests. But the principle applies in English cases, domestic cases, in exactly the same way. Instances, for example, of the extinguishment of a proprietary interest would be, for example, circumstances in which the interests of the beneficiaries are overreached. So, for example, an equitable interest could be overreached on a conveyance to a purchaser of a legal estate in land if the conveyance is made by trustees, two trustees, and the proceeds, made by trustees, and the proceeds of sale are paid to two trustees or a trust corporation. That's Section 2 of the Law of Property Act. So in that scenario, for example, where two trustees dispose of the trust property in breach of trust, and it's paid away, the purchaser or the recipient, let's assume for these purposes that they're not acting in good faith, the recipient simply pays some monies to the trustees. That would overreach the beneficiary's claim. That would extinguish their proprietary claim. What they'd be left with would be a claim for knowing receipt. Another example where a proprietary claim is effectively extinguished is in the context of registered land, where registered land is subject to a trust. A transferee for valuable consideration will take free of the beneficiary's interest, even if the transferee had noticed the transfer was in breach of trust, unless the beneficiaries are in actual occupation at the time of the disposition. That's Section 29 of the Land Registration Act. Now, all of these are instances of circumstances in which at the time of the defendant's receipt, the claimant's equitable interest was extinguished against the defendant. Mr. Justice Fancourt held, and the Court of Appeal agreed, if the property received by the defendant was not trust property at that point of time, there could be no liability for knowing receipt. Now, in the Court of Appeal, the court placed considerable reliance on the dicta of Mr. Justice Millett, as he then was at first instance, and in the Court of Appeal in Macmillan and Bishopsgate Investment Trust. Now, in that case, shares in Berlitz, which was a company incorporated in New York, were held by Bishopsgate as nominee for Macmillan and were wrongfully used to secure loans to Robert Maxwell's group of companies. So they've been misapplied in Bishopsgate's favour. Macmillan asserted a proprietary and personal claim, i.e. both a proprietary claim and a knowing receipt claim, to the ultimate proceeds of sale of the shares. That claim failed, Macmillan's claim failed under New York law. Bishopsgate was under that law treated as a bona fide purchaser for value without notice. What was significant for present purposes and was relied upon by the Court of Appeal in Byers was that the central proposition that was relied upon in Macmillan was that its entire claim, whether as a proprietary claim or a claim in knowing receipt, rested upon having what was described as an undestroyed proprietary base. If there is no longer any subsisting proprietary base to the claim, then it fails both as a proprietary claim and also as a claim in knowing receipt. So the key takeaway point in relation to Byers is that for a knowing receipt claim to be maintained, there has to be a coincidence between the unconscionable knowledge of the recipient and the payment of the way of monies in breach of trust, such that the trust status is still subsisting. If the trust status disappears, then there is no knowing receipt claim. That principle was illustrated as well in the second of the cases that I want to have a look at also this year, a case called ED&F Man Capital Markets and Come Harvest Holdings. That was the decision of Mr. Justice Calver in the Commercial Court that was handed down in February of this year. It's factually a complicated case. It involved an elaborate fraud to the tune of approximately $280 million by the production of forged warehouse warrants in respect of the sale and repurchase of nickel. There were various defendants who were involved in the fraudulent scheme, the principal defendants, the parties with whom the claimant had transacted, took no part in the proceedings. The issue in the case almost entirely turned on issues between the claimant and a party further down the chain, so to speak. That was the 10th defendant. And there were issues in which the claimant made allegations of deceit, unlawful means conspiracy, inducing breach of contract, and also a claim for rescission. And the interest for present purposes is what was the consequence of the claim for rescission. Now, it's well established that where a claimant succeeds in rescinding a contract that was entered into on the basis of some deceit, that does not render the contract void ab initio. What it does do instead is give the claimant a right to elect to avoid the contract. Now, in the event that the claimant does avoid the contract, what is then imposed by means of effectively a legal fiction is a constructive trust in which the defendant is then held to have is treated as holding the monies or other assets that it's received from the claimant on some form of retrospective trust for the claimant. So in simple terms, if on day one the claimant pays money to the defendant pursuant to a contract that it's entered into on the basis of some deceit, the legal and beneficial ownership in the monies that are paid away by the claimant at that point of time belongs to the defendant. If the claimant then subsequently succeeds in rescinding that contract, either by some appropriate act of its own or by some order of the court, there is then imposed a retrospective constructive trust, such that if the defendant is at that point of time still in possession of the claimant's assets, they'll be held on trust for the claimant, and the claimant can assert a proprietary claim to them. Furthermore, the claimant will be entitled to trace its assets into any other assets that have been substituted for the asset the defendant has that is received from the claimant. So that's the starting point. The interesting issue in Mann was whether those circumstances would also give rise to a claim for knowing receipt. And the argument was as follows. What the claimant says was, we have paid all of these monies to the defendants that have substantially ended up in the hands of the 10th defendant. The 10th defendant was implicated in the improper scheme, and indeed the judge found that they were liable for conspiracy. So in terms of a trust analysis and a knowing receipt analysis, what the court had found was that the 10th defendant had unconscionable knowledge of the nature of the transactions. So the claimant then said, well, if they have got unconscionable knowledge of the nature of the transactions, then given that it has now been declared that the monies that they're holding are held on constructive trust, then they should be liable for knowing receipt of all of the monies that they have received prior to the rescission of the contract and prior to the imposition of the trust. Now, that argument was rejected. What Mr. Justice Calver did was he adopted the approach of Mr. Justice Fancourt. At the time that he delivered this judgment, it appears that he hadn't seen the judgment of the Court of Appeal, albeit that the Court of Appeal's judgment had already been handed down by that point in time. He adopted the analysis of Mr. Justice Fancourt, which of course was subsequently approved by the Court of Appeal in buyers, to the effect that said, at the time at which you receive the property, you have to receive it in the nature of trust property, or alternatively, you must subsequently discover that it's trust property. So, to the extent that at the time that there was receipt of the monies by the 10th defendant from the claimant, the property was not subject to any trust because there had been no trust that had been determined by the court, because the contract had yet not been rescinded. Mr. Justice Calver said, in those circumstances, the monies are not subject to any knowing receipt claim, and a knowing receipt claim won't lie for the simple reason, and adopting the Court of Appeal's phraseology in Byers, that there's no coincidence between the unconscionability and the breach of trust. Now, the judge further commented that the absence of a knowing receipt claim wouldn't leave the claimant without a remedy. Firstly, it would have proprietary tracing claims to the extent that assets can still be identified, and will also have personal claims for unjust enrichment. Also, although it's not noted by the judge in this part of his judgment, the claimant might well have claims against the defendant on the basis of unlawful means conspiracy, on the basis that he has found that effectively they were participants in the scheme and therefore had effectively unconscionable knowledge of it. They could be, and indeed on the facts of that case, were indeed held liable for being participants in the conspiracy. So whilst in a case of this nature, the question of whether or not there could be a claim for knowing receipt is of some intellectual interest, for practical purposes, it probably goes not very far. And the reason that it goes not very far is indeed the very point that if you have the defendant who has some form of, let's call it, naughty or guilty knowledge, then they're going to be personally liable on one basis or another, albeit that there may not be a proprietary claim because they're no longer in possession of the traceable proceeds of the claimant's money. So whilst Mann is the subject of an appeal in relation to various issues, and it decided all sorts of points, it seems to me that it's going to be very unlikely that any appeal in relation to the knowing receipt point is going to get very far, if indeed that is a point that is being appealed, for the simple reason that the reasoning, Mr. Justice Fancourt's reasoning in Byers was endorsed by the Court of Appeal, and that at heart is the root of Mr. Justice Calver's reasoning in EDF Mann. The second group of issues that's relevant for today's discussion that was considered by Mr. Justice Calver concerned the potential defences to the proprietary claim. Now, this was as follows. Monies had been paid by the claimant to the parties with whom it had contracted. They were defendants, but they didn't take any part in the proceedings. Those parties became trustees of the money paid to them by reason of the rescission that I've mentioned. They paid various monies down the line, including to the 10th defendant, as well as to various other parties. And the monies they paid down the line were paid out of mixed accounts. In other words, the monies that were paid by the claimant were paid by those parties, those initial parties with whom the claimant had contracted, into mixed accounts and were paid out. Now, there's a very long-standing dispute or inconsistency, let's put it that way, in the cases as to the proper approach in a tracing claim to monies paid out of a mixed bank account. And there are two lines of approach to that in simple terms. The first says where monies are paid into a trustee's account, there's a mixed account, and he then pays money out to a third party against whom the claimant wants to trace its assets. The first approach says, well, actually, the money that's paid out is the trustee's own money, and that's the starting point. If it's the trustee's own money, on the principle that the trustee would spend his own money rather than somebody else's monies first, then there's no ability to trace because the claimant's money hasn't gone further down the line. The alternative view is that that's actually not what takes place. What takes place instead is that what gets paid down the line are the claimant's monies, and the misapplication of the claimant's monies out of the mixed account means that the claimant has a surviving tracing claim against the ultimate recipient. Now, in practical commercial terms, much of this, of course, turns on who is the solvent party. If the trustee is the party that becomes insolvent, as is typically the way, then, of course, one is going to find that the claimant is going to want to be advancing a proposition that says that it's the claimant's money that's been paid further down the line. And what survives are its tracing claims against the recipient. Now, I mentioned that this is the subject of some rather long-running difference of judicial opinion. In Shalson and Russo, which is probably the leading recent authority in recent years on the principle of rescission leading to the imposition of a constructive trust, Mr. Justice Reimer said, and this was all obiter, he said that the approach whereby the claimant could seek effectively to trace its money out of the mixed account into a third party's account was effectively a cherry-picking exercise. But he said that that was effectively permissible. He said in a case in which the only contest is between the claimant seeking to trace and the wrongdoer, there is every reason why the latter's interest, i.e. the wrongdoer's interest, should be subordinated to the claimant's. Normally, it is presumed that if a trustee uses money from a fund in which he has a mixed trust money with his own, he uses his own money first. And that goes back to the 19th century decision in Re Hallett. But it was submitted in that case that this is not an inflexible rule, and if the trustee can be shown to have made an early application of the mixed fund into an investment, the beneficiary is entitled to claim that for himself. And so in Shalson, albeit obiter, Mr. Justice Reimer was of the view that it would be permissible for the claimant to effectively trace out of the mixed account into the subsequent account into which the money was paid by the defaulting trustee. Now, an entirely different view of that was taken by Mr. Justice Patton in a case called Turner in Jacob in 2006, in which he said, it seems to me that in a case such as the present, where the trustee maintains in the account an amount equal to the remaining trust fund, the beneficiary's right to trace it is limited to that fund. It's not open to the beneficiary to assert a lien against an investment made using monies out of the mixed account. So here we have two first instance decisions based on some old authority that itself it sets out a series of what are no more than presumptions, equitable presumptions, as to the proper approach in relation to a tracing claim of monies paid out of a mixed account. Now, in Mann, in EDF Mann, Mr. Justice Calver accepted the defendant's contention that the money that was paid by the trustee ought to be paid with his own money. His reasoning is, to my mind, at any rate, leaving aside questions of authority, rather strange. What weighed with him would be that it would be unfair to the 10th defendant, i.e. the defendant who was the active defendant in the proceedings, to be liable for monies received by it when there were other recipients of monies from the mixed account who were not bona fide recipients, who were not parties to the litigation or are not taking any active part in it, in circumstances where they were not liable in respect of the monies that they received, but the 10th defendant would be liable in respect of the monies that it received. Now, to me, that seems a rather unprincipled conclusion. The fact that defendant A is sued for monies that it's received, but a potential defendant B isn't sued, or if sued takes no part or has become insolvent and has got no means of paying, is neither here nor there. We're in the realms of establishment of property rights here. And whether property rights are established or not is quite a quite separate issue as to whether or not the claimant elects to bring proceedings against other parties. Now, I indicate that this is decisions on its way to the Court of Appeal. To my way of thinking, this aspect of Mr. Justice Calver's reasoning appears to be quite unsustainable. But this question of how monies are to be treated out of a mixed account remains one that there is no clear authority that points one way or the other, that ultimately is a series of presumptions, effectively of convenience, that are used, and leaves claimants and defendants in a position of considerable uncertainty of the way in which those sorts of circumstances will be resolved. The second issue that was of interest in Mann concerned not so much questions of knowing receipt, but was a second issue in relation to an equitable proprietary claim, and that is the scope of the defence that's open to the defendants on the basis that it's a bona fide purchaser for value without notice. And there were two elements of the defence that was advanced by the 10th defendant that are of interest. The first concerned this. There were a number of payments that had been made by the claimant that were pursuant to fraudulent transactions. And there were a number of other payments that were made pursuant to transactions that were not fraudulent. Ultimately, the monies that were paid by the claimant found its way to the 10th defendant. And the 10th defendant said, well, we shouldn't be liable for monies that we received in relation to transactions that were not linked to the fraudulent transactions. And the reason we shouldn't be liable is in relation to those, we're bona fide purchasers for value without notice. And they said, furthermore, the notice that is required in considering the test for such a defence is notice of the specific transactions that are complained of. So if there is a complaint that transaction A is a fraudulent transaction and transaction B is not a fraudulent transaction, if we, the defendants, have received monies in relation to transactions A and B, we've got a good defence in relation to transaction B, but we might not have in relation to transaction A. Mr. Justice Calver rejected that. And he rejected that based on principles established both in the Privy Council in a case called Credit Agricole Papadimitriou in 2015, and in a much earlier decision of the House of Lords in Midland Bank Trust Company in Green in 1981. In Papadimitriou, the Privy Council identified effectively three types of notice. One is where a party appreciates that a proprietary right in property probably exists and so has actual notice of that claim. The second is where a reasonable person with attributes of the defendant, in that case, of course, a bank, should have appreciated, based on the facts already available to it, that the right probably existed, in which case it would have constructive notice of it. And the third is where a party should have made inquiries or sought advice which would have revealed probable existence of such a right, in which case they also have constructive notice of it. If a defendant knew of sufficient facts that might have revealed the existence of proprietary rights, then it will be treated as having notice of them. That is an essential element of the good faith defence. Now, that's what was said in Papadimitriou. In Midland Bank and Green, the House of Lords said in very clear terms that the defence of bona fide purchaser for value in good faith without notice contains a number of distinct elements. And importantly, the question of good faith is a separate, distinct element from notice. So in circumstances in which one might not have had notice of a proprietary claim, but nevertheless the defendant was not acting in good faith, then it wouldn't have a defence. Now, what Mr. Justice Calver decided in May was that the tenant defendant was so implicated in the improper scheme that it was not a party that was acting in good faith. And as it was not a party that was acting in good faith, then it couldn't have a defence to the claim. Now, the case is rather mired on its fact in a lot of detail. It's a very extensive judgment, there's over 600 paragraphs long. But what you have is, as I indicated earlier, some transactions in which there is a clear proprietary claim because they are fraudulent transactions. And other transactions where there isn't such a claim because the claim was not fraudulent. It seems to me that it's rather difficult for a claimant to establish that it's got a proprietary claim in relation to a transaction itself that was not entered into pursuant to the fraud. Part of the problem that I think one probably encounters in that case on its facts is that all of the transactions are so sort of mired up within themselves that the right to rescind that the claimant exercised was a right to rescind in relation to all of the transactions. And so one has a circumstance where if all of the transactions are rescinded, even though some of them in terms may have been fraudulent and other ones might not have been, then the entirety of the monies that have been held by the counterparty to the transaction, the original trustees, so to speak, is subject to a constructive trust. And then all of the payments that go down the line are subject to that trust obligation, notwithstanding some of them may have been specifically fraudulent and other ones might not have been. And I think it's in that context that one has to take account of the general point of principle that is being discussed in that case in Mann, applying in particular the principle in Midland Trust Bank and Green, that the operation of a good faith element of the defence, the equities darling defence of knowing a bona fide purchaser for value without notice is a separate and distinct element from the claim for the question of notice. And that for the defence to operate, the defendant has to show both elements, that it A, had no notice of a sufficient kind, and B, that it was acting in good faith. One sees a lot of cases in which there is argument about the extent of the defendant's knowledge, but what's often left to one side and not properly explored is the extent to which the defendant is acting in good faith. Now, of course, the question of good faith is somewhat of a nebulous concept and is not always easy by any stretch of the imagination to establish. Now, I'm conscious that I've explored cases that are not directly what may be described as proprietary claims in insolvency as such. What they are cases that bear upon the way in which proprietary and knowing receipt claims can be pursued, and the limitations of such claims that can be pursued by office holders, or alternatively, of course, if they're claims brought by third parties against companies in liquidation or administration, the same principles, of course, apply. There's nothing further I'm proposing to say. Thank you very much for attending today's seminar.